Have you ever wondered what happens when a law, an act, or an omission is inconsistent with the 1982 Constitution? Wonder no more. Hello, everyone. My name is Habiba Bakari, and this is Amira's Haven. In this video, I'll be discussing the Constitution as a source of law in Ghana. Article 1 plus 2 of the 1992 Constitution outlines that the Constitution is the supreme law of Ghana, and any other law found to be inconsistent with it will be rendered null and void to the extent of that inconsistency. Article 2 plus 1 also outlines that any person who alleges that an enactment or part of an enactment or an act done under an enactment or an action or an omission of a person is inconsistent with the Constitution may bring an action to the Supreme Court for a declaration to that effect. In the case of NPP versus Attorney General, the 1979 Constitution was overthrown by PNDC on the 31st December 1981. The PNDC ruled the country until the coming into force of the 1993 Constitution on 1st January 1993. On the coming into force of the new Constitution, the leader of the PNDC was voted into power by the citizen as a democratic leader. On the 14th of December 1993, there were publications in the newspapers that government had allocated funds for the celebration of 31st December as a public holiday. The plaintiff brought an action to the Supreme Court for a declaration that the public financing of 31st December and the celebration of that holiday were inconsistent with the 1992 Constitution. The court upheld the plaintiff's claim. It held that the continued celebration of 31st December in commemoration of a coup in a democratic era was inconsistent with the Constitution. The court outlined that the Constitution 1992 had outlined or provided stiffer punishment for any person who plots a coup. So that same Constitution cannot be said to encourage any act that celebrates or encourages a coup. Also, if 31st December is celebrated, it will encourage other people to plot coup or to overthrow the Constitution. The next case I would like to talk about is the case of Adolfo versus Attorney General. In this case, the plaintiffs were former employees of the Ghana Cocoa Board who were made redundant and their appointments terminated. When they asked about their terminal benefits from their employer, they were told that the Ghana Cocoa Board was indemnified from paying any terminal benefits to the employees. And the law that was used to terminate their appointments. Also, the plaintiff could not bring an action against Ghana Cocoa Board for any issue arising out of the failure of the board to pay them their terminal benefits. The plaintiff brought an action to the Supreme Court for a declaration that that section of the law were inconsistent with the 1992 Constitution. The court upheld the plaintiff's claim and held that insofar as that law ought to or sought to oust the jurisdiction of the courts and prevent the plaintiff from exercising their constitutional rights, that law was indeed inconsistent with the 1992 Constitution. The last case I would like to discuss is the case of Tufo versus Attorney General. In this case, the highest court of the land under the 1969 Constitution was the Court of Appeal, which was headed by Chief Justice Fred Apalu. On the coming into force of the 1992 Constitution, the President, acting in consultation with the Judicial Council, appointed the incumbent Chief Justice to be the Chief Justice under the new Constitution. The Chief Justice was brought before Parliament for vetting. However, Parliament did not approve of his appointment. The issue in contention in this case was whether or not the Chief Justice under the 1969 Constitution remained as Chief Justice under the new Constitution, even though Parliament had not confirmed his appointment. The court held that the Chief Justice under the old Constitution remained the Chief Justice under the new Constitution. The rationale given by the court was that if all public officers were to be removed from their position by virtue of a change in Constitution, that will not be a fair interpretation of the Constitution as a whole. And also, the Constitution had provided provisions for the removal of a Chief Justice and procedures to be followed to do so. Since it will not be proved that Chief Justice Apalu had done anything that will warrant his removal or anything that will fall under as a ground or fall under the grounds of removal of a Chief Justice, he could not be removed as a Chief Justice. Therefore, he will continue to be the Chief Justice under the 1979 Constitution. In conclusion, the 1992 Constitution is the supreme law of Ghana, and any other law that is, or any act of an individual or omission of an individual that is in contravention or is inconsistent with the Constitution will be held to be null and void and of no effect. I hope you learned something today. If you found value in this video, please like, comment, share, and subscribe. I look forward to answering any questions regarding this video. Until next time, have a lovely day.